Okay, so we're going to test this out. This is the most wonky setup ever, so don't know if it's working. But I am starting a new channel called Sovereign War, and it is basically about the war between auditors and the people who call them frauditors, and then there's sovereign citizens, and there's everybody else just sitting there and watching. So, first thing I want to do is talk about um, DirectD here. This is DirectD's sentencing, and I want to take a listen to what he's sentenced to. So 90 days in jail, 24 months of probation, and then he's sending him to Prodigy Healthcare for counseling. The problem with that is that means that the judge had indications or believes by the judge's own judgment that DirectD has some sort of mental health disorder that he needs treatment for. The problem with that is there was no treatment scheduled before trial, and then now the judge is making treatment part of the punishment, so he's using treatment as a punitive measure. And this is basically a little bit about what the court has to say about that. And this is constitution.congress.gov, so they have no authority over this kind of thing. The Supreme Court has held that it is a denial of due process to try or sentence a defendant who is insane or incompetent to stand trial. Now, I'm not saying that DirectD is necessarily insane or incompetent to stand trial. The judge said that by ordering treatment. But as you can see right here, it's a denial of due process not to have that done first. And there's the case sightings. We got Pate versus Robinson, 383 U.S. 375, and we have Dusky v. United States, 362 U.S. 402. That was in 1960 and 1956. So that kind of indicates that DirectD got screwed. And what we'll do now is I want to talk a little bit about this whole situation, because if you look up what happened with DirectD, he was in the area, approached the scene, and then his viewers like me want to listen and partake in what's going on, and we're curious about traffic stops and how the police institute their traffic stops and how that goes. And I believe there's an overall feeling that people think that the United States isn't what it used to be. Like 9/11 changed something fundamentally. And what I have a curiosity about is when you get pulled over, that's not called an interrogative detention. That's a roadside stop. It's a brief detention. I mean, they can ask you questions, but you're not required to answer pretty much any of them. All you have to do is provide your ID or your name, date of birth. You're driving, so you really should have a driver's license. So you have to provide that, your registration and proof of insurance. And that pretty much encompasses everything that you have to divulge when you get pulled over. And we all know that police like to expand the stops and get more information. Where are you coming from? Where are you going? And they're looking for inconsistencies in your responses so that they can say that you were guarded, or you were concealing information, or you were lying. So that elevated suspicion. But then when somebody comes up on the scene and they create this buffer zone, what they're really doing is creating an interrogative detention. Because now what the Supreme Court has said is that if you have this public disclosure and this public stop, the public is there, so there's a check to the police authority in questioning you, and people can hear what's going on, and maybe they can interject. There's a Supreme Court case on that, and I'll get into that later. I tried to file a motion to intervene in delete laws as a federal lawsuit, and I guess I didn't do very good, but I'm not a lawyer, so that doesn't really surprise me. I mean, there are 95,000 pages of federal statute. The Code of Federal Registers is just as big, if not bigger, but I don't have those numbers. But if you go to recap, it's Court Listeners Recap. You go down here to Court Listener, and let's see. You can go to bulk data, and you can actually download all of the stuff that they have. Here's the browse the bulk data, and just the opinions text. Sorry, this is still loading. My internet is not very good. Anyways, it's 30 gigabytes compressed. Uncompressed, it's about 200 gigabytes of text. And that's just the opinion text. So that equates to somewhere around 100 million pages of opinion text that you have to read to follow law. It's not anything that's human capable. And what's really concerning about the police is that what they do is they say that you're on the scene and that's a safety hazard. Even though, I mean, if you meant the police ill will, why would you walk up on scene with a camera? Why wouldn't you just do a good old-fashioned drive-by shooting? I mean, that would be a surprise. It'd give you the advantage, all that stuff. I'm not saying that anybody should. I'm saying that this call to safety is just nonsense. And in fact, there's a new law in it's SB 362 out of Nevada, and that law is this is the law right here. And basically what it says is it requires a police officer to ensure medical aid is rendered to a person. And it also, this is very interesting, it requires each law enforcement agency to adopt certain policies and procedures governing performances by police officers of works protected by copyright in certain circumstances. And what that really is that's that thing where police were playing copyrighted music so that you couldn't post any of their acts, because then it would get copy struck. And the wording here is, it says that bill will require agencies. This is it right here. Anyway, so what it shows is the police officers have adopted this stance where they don't want to be recorded because it's nothing but bad for them if they can't control the narrative. And here's proof. If they wanted all these people to move back, they could run over to Amazon here and they could pick up this FM transmitter, and it works for about 200 meters or 600 feet or so. And anybody could tune in and listen to what the police are saying. And then they would be able to move back and they would be able to hear what was going on. It would be a win-win. Everybody would be happy. But that's not America anymore. America now is, fuck you. You'll do what I tell you. And that's a music lyric. But that's basically the stance of the police. And it gets worse because qualified immunity is all based on um, basically what happened was they passed the Civil Rights Act in I think it was 1871, and in that act, they it supposedly didn't discuss anything to do with the existing common law defenses that were known as immunities. And since the law supposedly didn't address that fact, the Supreme Court converted those common law defenses into what is known as qualified and absolute immunity today. And this is out of the Fifth Circuit Court of Appeals. The case here is kind of irrelevant. That's why you'll see here's the case title, and it's 21-2200. And it was filed March 30th. And that's why, you have the starting of the opinion. And I said, opinion about this case removed, because it's not what's important. What's important is how the judge concurs with himself. And he says, today's decision upholding qualified immunity is compelled by our controlling precedent. I write separately only to highlight newly published scholarship that paints the qualified immunity doctrine as flawed fundamentally from its inception. For more than a half century, the Supreme Court has claimed that certain common law immunities existed when 1983 was enacted in 1871, and no evidence suggests Congress meant to abrogate these immunities rather than incorporate them. But what if there were such evidence? Indeed, what if the reconstructed Congress had explicitly stated right there in the original statutory text that it was nullifying all common law defenses against 1983 actions? That is, what if Congress' literal intent unequivocally negated the original interpretive premises for qualified immunity? Professor Alexander Reinhardt argues precisely this in his new article, Qualified Immunity Flawed from Foundation, that courts have been construing the wrong version of 1983 for virtually its entire legal life. Wait a minute, what? Okay, so as passed by the Reconstruction Congress, Section 1 of the Civil Rights Act of 1871, now colloquially known as 1983, read this way: any person who, under the color of any state, any law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall any such laws, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. This part right here you won't find in this sentence is gone from all of the books, and this is how it happened. The italicized language, the notwithstanding clause, as Professor Reinhardt calls it, explicitly displaces common law defenses. The language that Congress passed makes clear that 1983 claims are viable notwithstanding any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary. The language is unsubtle and categorical, seemingly erasing any need for unwritten gap-filling implications, importations, or incorporations. Rights violating state actors are liable, period, notwithstanding any state law to the contrary. Then things went off the rails quickly and stealthily. For reasons lost to history, the critical notwithstanding clause was inexplicitly admitted from the first compilation of the federal law in 1874. The reviser of federal statute made an unauthorized altercation to Congress's language, and that error was compounded when various revised statutes were later published in the United States Code in 1926. The reviser's error, whether one of omission or commission, has never been corrected. Today, 152 years after Congress enlisted the federal courts to secure American constitutional rights, if one were to Google 42 USC 1983, the altered version that pops up says nothing about common law defenses. According to Professor Reinhardt, that faithful, unexplained omission means that courts and scholars have never grappled with the notwithstanding clause significance. All to say the Supreme Court's original justification for qualified immunity, that Congress wouldn't have obligated common law immunities absent explicit language, is faulty because the 1987 Civil Rights Act expressly included such language. Those 16 lost words, by presumably encompassing state common law principles, undermine the doctrine's long professed foundation and underscores what the 1871 Congress meant for state actors who violate Americans' federal rights is not immunity, but liability. Indeed, liability notwithstanding any state law to the contrary. So basically, imagine this judge, he's reading all this, but he's bound by precedent. So he has to deny this poor person, Kevin Rogers, any relief, but he doesn't believe that he's doing the right thing. And that, anyways, I thought you guys might want to address that a little bit. And I want to start a new website. I think it's most interesting, the war between the auditors and the frauditors, or the frauditors and the auditors of the frauditors, or basically the online shitstorm that is all this bullshit. I mean, yeah, you might be able to go into a post office and record because the sign on the wall says that, but the more you abuse that and put, little old grandma at 73 years old on the TV without giving her a chance to doll up and, dress for the part, she's going to be upset, and so is everybody you offend that she knows. So, maybe you can audit stuff, but should you? And should you do it the way that you're doing it? It remains to be seen. My point is, this judge in this case can't have it both ways. If Christopher Ruff needs mental health treatment as part of probation, then the judge should have had him evaluated before sentencing, and that is a reversible error, no matter if Mr. Ruff is screwed up his appeal or not, because the Americans with Disabilities Act is a federal law. Just think about that for a moment while everybody's got their mind made up on this whole situation. Anyways, we'll see how this worked.